As 2025 ends, all eyes are on the U.S. Supreme Court, where the justices are deciding whether to take up major gun rights cases. The focus state laws in places like Washington and California that ban high-capacity magazines, devices that hold more than 10 rounds of ammunition. Conflicting lower court rulings have created a patchwork of laws, leaving gun owners and law enforcement in limbo. The Supreme Court's recent move to relist these cases signals that a major decision could be imminent. For both gun rights advocates and gun control supporters, this is the long-awaited showdown that could reshape the Second Amendment. The outcome could either invalidate magazine bans in over a dozen states or empower states to enact stricter regulations. As 2026 approaches, the Supreme Court's deliberations are set to define the future of gun rights in a deeply divided nation. Magazine bans are laws that restrict the number of rounds a firearm magazine can hold, setting a legal limit on how many bullets can be loaded at once. These laws are designed to address concerns about rapid-fire capability and the potential for mass harm in violent incidents. Most commonly, the cap is set at 10 rounds, though some states allow magazines that hold up to 15. The difference between a 10-round and a 30-round magazine can be significant, especially in the context of how quickly a shooter can fire before needing to reload. Currently, 14 states and Washington, D.C. have enacted magazine capacity limits, but the specifics of these laws can differ widely. For example, Colorado allows up to 15 rounds, while California and New York restrict magazines to 10. Some states even have different rules for handguns versus rifles. These bans are often passed in the wake of high-profile mass shootings, with lawmakers arguing that limiting magazine size can reduce the number of casualties by forcing shooters to reload more often, giving potential victims and law enforcement precious extra seconds to intervene. Many states with magazine bans include so-called grandfather clauses. These provisions allow people to keep magazines they owned before the law took effect, but ban the sale, transfer, or importation of new high-capacity magazines. This creates a patchwork of legal and illegal magazines within the same state. Supporters of magazine bans argue that these laws can save lives, not only by limiting a shooter's firepower, but also by giving bystanders and police more time to react and potentially stop an attack. They point to studies suggesting that mass shootings involving high-capacity magazines tend to result in more injuries and deaths. Critics, however, argue that magazine bans create a confusing legal landscape. In some cases, simply crossing a state line with a magazine that is legal at home can turn a law-abiding gun owner into a criminal. This patchwork of laws can be difficult to navigate, especially for travelers and those who move between states. Gun rights advocates also point out that magazines holding more than 10 rounds are standard equipment for many popular firearms, including those used for home defense, sport shooting, and hunting. They argue that millions of these magazines are in common use across the country. From their perspective, banning these magazines infringes on the fundamental right to self-defense, making it harder for law-abiding citizens to protect themselves and their families in dangerous situations. The end result is a deeply divided nation, where the legality of a single magazine can change dramatically from one state to the next. This inconsistency has led to ongoing debates and legal challenges. At the heart of the current Supreme Court battle is whether these state-level magazine bans violate constitutional rights, or if they are a reasonable measure to promote public safety in America. Magazine bans pit public safety against the right to bear arms. Supporters say limiting magazine size is common sense. Fewer rounds mean more chances to stop a shooter. They argue most self-defense situations require only a few shots, so 10 rounds is enough. Opponents counter that these laws weaken self-defense, especially against multiple attackers, and criminals will ignore the bans anyway. They point out that millions of Americans own these magazines for lawful reasons, and banning them criminalizes ordinary people. Critics also question the effectiveness, noting that reloading can be done in seconds. For gun rights advocates, magazine bans are an unconstitutional burden. For supporters, they're a necessary step to reduce gun violence. The Supreme Court's decision to relist magazine ban cases signals a serious and growing interest in finally resolving the contentious issue of magazine capacity limits. This move is often seen as a sign that the justices are taking a closer look, weighing the broader implications for both gun rights and public safety. Since the landmark 2022 Bruin decision, lower courts across the country have been deeply divided on whether magazine bans are constitutional. Some judges have struck down these laws while others have upheld them, leading to a patchwork of conflicting rulings and widespread legal uncertainty. This split has created confusion for law enforcement, gun owners, and lawmakers alike. The Supreme Court often steps in to resolve such splits among lower courts, ensuring that federal law is interpreted and applied consistently nationwide. Their intervention is crucial when fundamental rights and state laws collide. If the court upholds the bans, it could open the door for more states to pass similar restrictions, emboldening lawmakers who support stricter gun control. This would be seen as a significant victory for those advocating for tighter regulations on firearms and ammunition. On the other hand, if the court strikes down these bans, it would immediately legalize standard capacity magazines in many states where they are currently prohibited. Such a decision would be celebrated as a major win for gun rights supporters, reshaping the legal landscape overnight. Either way, the Supreme Court's ruling will set a powerful and lasting precedent, shaping how future challenges to gun laws are decided and influencing the direction of Second Amendment jurisprudence for years to come. The stakes could not be higher. The decision has the potential to fundamentally reshape gun regulation across the entire nation, affecting millions of Americans and the laws in dozens of states. Both sides of the debate are bracing for a landmark ruling, with activists, politicians, and everyday citizens anxiously awaiting the outcome that could redefine the boundaries of gun rights and regulation. The outcome will ripple through every state, impacting not just current laws but also future legislative efforts and court battles over gun policy. As the nation waits for the court's next move, the eyes of America, and the world, are fixed on the Supreme Court, knowing that its decision will echo for generations. Washington and California are at the center of the magazine ban fight, representing two of the most closely watched battlegrounds in the ongoing debate over gun rights and public safety in America. Both states have enacted strict laws limiting the capacity of firearm magazines, sparking intense legal and political battles that have drawn national attention. In Washington, a 2022 law banning magazines that hold more than 10 rounds was initially struck down by a county judge, who argued it violated constitutional protections. However, the state Supreme Court quickly stepped in, reinstating the law while legal appeals continue, leaving gun owners and law enforcement in a state of uncertainty. The court's reasoning was that magazines are considered accessories rather than arms themselves, and therefore do not receive the full protection of the Second Amendment. This interpretation has become a focal point in the legal debate, with advocates on both sides presenting passionate arguments. Meanwhile, California's long-standing ban on high-capacity magazines has faced years of legal challenges, with gun rights groups repeatedly seeking to overturn the law. The influential Ninth Circuit Court of Appeals recently upheld California's ban, reinforcing the state's authority to regulate firearms and accessories. The Ninth Circuit found that the ban is consistent with the nation's historical tradition of regulating dangerous weapons, a key standard set by recent Supreme Court decisions. This ruling has set a significant precedent for other states considering similar laws. These conflicting rulings between Washington and California have set up a direct challenge for the U.S. Supreme Court, which now faces pressure to resolve the issue and provide clarity for the entire country. The Washington case specifically asks whether magazines should be classified as arms under the Second Amendment, a question that could reshape how courts interpret gun rights nationwide. The California case, on the other hand, questions whether such bans fit within the historical tradition of firearm regulation, as required by the Supreme Court's landmark Bruin decision. This historical analysis is now central to Second Amendment cases. By considering both cases together, the Supreme Court has the opportunity to address the full range of legal arguments, from constitutional definitions to historical context, and set a nationwide standard. The decisions in these two states have brought the national debate over magazine bans and gun rights to a head, with Americans across the country watching closely to see how the highest court will rule and what it will mean for the future of gun laws in the United States. The 2000 under den ponderender 20 indam boan duais to Bruin decision changed how courts review gun laws, replacing a balancing test with a strict focus on history and tradition. Now the government must prove any gun regulation matches the nation's historical tradition at the time the Second Amendment was adopted. This shift has fueled new challenges to magazine bans. Gun rights advocates argue there's no historical precedent for limiting magazine capacity. Early repeating firearms weren't restricted, They say, under Bruin, modern bans must be struck down. States counter that there's a tradition of regulating dangerous and unusual weapons, and large magazines fit that category. They also point to old laws restricting gunpowder storage as a historical analogy. The Bruin decision has turned courtrooms into debates over centuries-old laws. Both sides now rely on historical experts to make their case. The Supreme Court must decide which history matters most. The legal fight centers on common use and historical tradition. Gun rights supporters argue that magazines over 10 rounds are in common use. Tens of millions are owned for lawful purposes. They claim banning them would outlaw a core component of self-defense firearms. Supporters of bans focus on the Bruin-mandated tradition test, arguing that even common items can be regulated if history supports it. They liken large magazines to historical weapons deemed too dangerous for civilian use. Some states argue magazines are accessories, not arms, and thus not protected by the Second Amendment. This legal strategy aims to give states more power to regulate. The Supreme Court must now decide how these arguments fit under the Constitution. The Supreme Court's decision will have immediate sweeping consequences. Striking down magazine bans would legalize standard capacity magazines in 14 states and D.C., setting a strong precedent for gun rights. Upholding the bans would affirm states' authority to regulate firearm accessories, likely encouraging more states to pass similar laws. Either way, the ruling will clarify the boundaries of the Second Amendment for years to come. The decision will impact millions of Americans, gun owners, law enforcement, and lawmakers alike. The nation awaits a clear answer on one of its most divisive issues. The future of gun regulation hangs in the balance.